Okay, guys, today's session on point of ACD. That's the High Court Division written exam. Which topics are very much important to study? That should be focused here. So first of all, I would like to focus in terms of several systematic way in terms of that. Okay, just watch the video. I will start. Okay, oh my God. We have already, oh my God. Okay. Just we have to share this video. Okay. Now matter that the syllabus prescribes that drafting of a memo of appeal against judgment, civil and criminal, and drafting of a habeas corpus petition, drafting of a quashment furthering, and not only that's the drafting of a civil division. And another topic is drafting of a writ petition. Okay, let's move. That the throat or the melody is not present, isn't present in my throat. Okay, that's the syllabus that should be discussed here. Just find out the approaching power. Oh my God, what happened exactly? We will test this. Oh my God, oh my God. So the systematic way, you have all have the opportunity to ask me several questions in terms of written exam. Anyone, please ask me several questions. And I'm trying at my level best to answer the question exactly. So the marks distribution for the High Court written exam is that the format. On point of format, you have 5 marks, and the another term is that fact. What is the fact of that very criteria? That can be termed as to the 5 numbers. And the prayer. How to pray? How to pray to God, how to pray to the teacher, and how to pray to the Chief Justice in our country from the side of saving care. 5 marks. And the language and style. So what type of language you use on your kata, and which style is followed by you. So on these points, you have 5 marks. And the last but not least, there's the laws and grounds, 5 marks. Laws and grounds, 5 marks. Again, please. Again, please. Oh my God. Okay. So this the marks distributions is like this. 5, 5, 5, 5, 5, over 25. Now the question pattern is smart question pattern, So the written test from the side of High Court Division to pass in that very exam, you should admit in the very dynamic coaching center in our country, and not only in our country, in the whole world, that is not actual. First of all, I would like to focus in terms of civil appeal. So what are the provisions of laws? We have to focus this. So how to draft a civil appeal? The techniques in this regard, DC and PY-GC. So what exactly the thematic approach like this, the systematic way in terms of DC here? So several aspects maybe the indicates of the first that's district. And then C indicates that the court, to which court that the civil, this the civil appeal lies. That's the two courts, like the district judge and the High Court division. Now the limitation period from the side of 152 of the Limitation Act 1908, the 30 days. But as to the High Court division, 90 days will be favored in this regard. Yes, there's the provision of laws, but the Code of Civil Procedure 1908 prescribes that's under section 96 to 112. And not only that, the word prescribes that 41 to the 45 orders. So those are the provisions of laws, but the Nagendranath versus Suresh and the prescribes in this regard. What is exactly this is the civil appeal. So the civil appeal prescribes that's the, also from the side of that aspect, the proceedings are taken to have a decision of lower courts to the higher court for possible reversal. So that can be several times I have focused in this regard, like this, the Black's Law Dictionary. And not only that, Nagendranath versus Suresh Tundro upholds its voice in terms of the civil appeal. Now the question may arise before us how to draft that. First of all, you have to focus and what this is the district name, and then the code. Number 3 is number of appeal or the appeal number or 2025. Actually, which number will be favored in this regard? And not only that, the number 4 is 40s. 40s is treated as to the appellant and respondent. But single appellant and if there exist several appellants, that times the plural concept may be added in this regard, like this appellants. Soundproof, Mr. Sufyan, I'm in live class. Just stop this phone, Mr. Sufyan. Just stop this. This is high time. We discussed in terms of civil appeal. What are the points through which students can write on their kata? So the first of all, this is the district name and then code, whether this is the district just code or the High Court division. That should be recalled, and that should be rearranged by your CPU, Central Processing Unit. And not only that, the number of or the appeal number, and then 4 is like this, the appellant and respondent, or the appellants or the respondents, and value of suit or appeal. Actually, how much that should be prescribed here or inserted in your drafting. And impugned JOPA, what exactly this is that JOPA means here? Impugned like this, the judgment or the petition and actions. Okay, and the G indicates that the grounds. What are the grounds exactly through which you can establish your civil appeal before the court of appellate court, like this, the district judge or the High Court division. And then last but not least, that is not last, that the certificate, this, the last is enclosure, whether this the certificate. I have focused several times. For example, I would like to focus in this regard that the 2024, that the question asked from the side of High Court division. So the systematic ways that the inclusive prescribe that's for Kalatnama, Kalatnama, and not only that's the several aspect, but how you actually study that, so that's discussed, made that should be focused, and how to draft these situational cases in terms of civil appeal exactly. So no one is watching this video. This is shame for the whole nation as we're living in darkness. And so this is the age of darkness, like this, the I am a Jahiliya. And that's why no one is watching this video. We have no power at all to cut out and to reach or go through the spectrum from the side of Lord towards the whole world. And this is shame for the whole nation. Oh my God. No one is watching this video. So this is very much shame. Well, no matter. So this is taking these situational cases like DCNP by GSC way. In this is situational cases like the first question, you have to actually draft a civil appeal. Okay, so this is very much easy, and this is very easy There is no hesitation in this regard. Now the question matter is how to actually systematic way which will be preferred here, and how to write this civil appeal systematic way. So that should be focused here, and how to actually discuss in this matter, and how to actually answer the question in terms of the civil appeal exactly. So the civil appeal, to understand this civil appeal, we have to focus several aspects, and side by side I would like to discuss. No one is watching this video. Oh my god, oh my god. Instruction, what exact the criminal appeal. Now the our tone in terms of civil appeal exactly. Now how to answer this civil appeal question pattern exactly. That should be focused here. And the praying grounds, all things, and all things should be mentioned here. Okay, guys, to understand this civil appeal, we have already discussed, we have already focused in this regard, but no one is watching this video. This is very much sample the whole nation and the full system in our country. And how can we challenge towards the whole world? Nothing. We have no actually power to challenge the whole society. And the whole society, of course, this is very sham for us. So civil appellate jurisdiction, for example, if you actually understand this systematic way, how to write that. First of all, I have focused in terms of district. So which district actually deals in this respect, whether this is the Dhaka, or the Borishal, or the Jaipurhat, Rangpur, Khulna, Silat. So that should be prescribed at the left side of the drafting position. You have to focus. And then in the Supreme Court of Bangladesh, that should be middle in nature. So this is the piece, but you have to eventually, and that can be focused in such way. This page should be the system distribute column evenly. So what exactly distribute column evenly? And the evenly means this is the what exact the middle point there should be. And first of all, this is the district name will be inserted left side, and then in the what exactly the Supreme Court of Bangladesh, that should be placed at the middle of that very page where you want to write something. So this in the Supreme Court of Bangladesh High Court Division, this is the civil appeal towards the High Court Division and civil appellate jurisdiction of the. So what exactly the within first bracket closing, and memorandum of appeal from original degree. So memorandum of appeal from original degree comes from the side of the 96 section 96 prescribed in this regard. And then what exactly the fact number of 2025 and first appeal number of 2025 and in the matter of. So how to write in the matter of exactly this is the right side. If you actually distribute to the phase evenly. So what exactly the distribute the phase evenly? So at the right side, you have to write the fact number, first appeal number, what exactly the way that the 42 of 2025 or the 72 of 2025, that should be inserted here. And not only that, in the middle, and you have to write here and the capitalization, that's the and. So what exactly the and is treated as the capitalization A and T in the middle of W. What exactly the wave of the let Samsur Rahman 72 lakh Borsakas column or the Eastern as of 48. What exactly this is the systematic way of the let Samsur Rahman 72 lakh Circus Kolabagan Thanmundi Taka 1205. So plenty. Here is the position movement like this, the what exactly the appellants as a single one, and that's why there is no option to use that the appellants. So in this case, or the draft petition, or the civil petition, or civil appeal petition, we have to focus the plaintiff as that the active role which is played by him, or that is treated as to the appellant. Or the process are shown of the Amber Head 46 by a Sector 703 and Uttara DHAKA defendant or the respondent. And not only this, this is a defendant appeal ballot attack. What exactly the appeal ballot? You know, this is the 5 code DHAKA. What a 50 code DHAKA. The 5 code DHAKA will be treated as to the districts. Well, so here the 50 code DHAKA. Oh my God, a big amount, and that's why the code name or the name of the code is treated as the high contribution. And not only that, being aggrieved. So this is the system, but how to write at the left, at the right side like this, the distribute the face badly. So what exactly the band of right side being aggrieved by and dissatisfied with the judgment and ticket target. What exactly the data 1/10 and 2025 ticket signed in 6/10/2025 passed by Mr. Farabi Islam and the learned joint teachers. First quote and DHAKA in the title set number 35 of that 2025 or the 2029 or exactly the 2023, whatever may be. You have to insert here. So the date and the word exactly the date and the year, and that should be mentioned in your question pattern with the accent movement like this. And not only dismissing the pseudo contrast in the plaintiff appellant Mebab named begs to prefer this appeal before this honorable code on the following amongst other. So this is the systematic way at the first movement. You have to write. And the civil appeal prescribed in this regard like this, the grounds and then grounds. So what are the grounds through which you can easily establish this civil appeal before the court? Oh my God, no one is watching this video. It is shame for the whole nation as we are living in darkness, and the darkness may be practiced in our country. So this is the systematic way. And what exactly the grounds exactly? What are the grounds through which you can establish this civil appeal before the court of high contribution? So this is the grounds for that. If you have to start at the left side of that very face and the full size for what exactly the numbering system number 1, 2, 3, 4, 5, 6, 6, oh my God, blah 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 blah. So what are the systematic way to establish this? The first ground is for that the subordinate trial court dismissed the suit against the plaintiff appellant upon the utter misconception of law. So the number 1 is the ground is like the misconception of law. So what exactly the misconception of law? Of course, there's the erroneous decision maybe occurred, maybe come from the side of the leg. And the subordinate court from the Islam has occasioned failure of justice. So how can actually a party may be aggrieved to file a civil appeal before the court of high contribution? That should be the number 1 is ground is that whether it is the misconception of law or the occasion failure of justice. Number 1. Okay, viewers, guys, okay. And number 2, the ground number 2, for that the learned subordinate just committed erroneous illegality and irregularity in the assessment of evidence and appreciation of law in its true perspective during the trial of the suit, and as such the same is liable to be set aside. So number 2 grounds prescribed, that's the number of keywords prescribed, that's the what exact the illegality or irregularity. But on what point like this, that the assessment of evidence. So this is the packing approach from the side of the subordinate code. And number 3 grounds, guys, have you understood what I delivered to you? That the systematic way you have to focus in this way. So no one is watching this video. This is sham for the whole nation as we are living in darkness. This is the Ayame Jahiliya. This is the Ayame Jahiliya. Mr. Sufyan. So we are living in Ayame Jahiliya again, and this is not the enlightened society from the side of Renaissance period. Number 3, for that learned judge erred both in law and facts. The keywords prescribed in this regard. Law and facts, this is the erroneously decided. from the side of the learned chess, from the side of the subordinate co. Here is the key point is the law and facts in passing the judgment and dismissing the suit against the plaintiff appellant, and just the same is liable to be set aside. So the common dialogue from the side of this systematic way that the language and stylish movement should be prescribed by you. So number 4, for that the judgment and dictate passed by the trial code is neither proper nor in accordance with the law, and as just the same liable to be set aside. Liable to be set aside. What exactly is liable to be set aside? That should be focused for you. Exactly the justice in our country. They can easily cast that. Number 5, for that the learned subordinate just failed to understand the facts and circumstances of the suit. What is actually the facts and circumstances of the case or the suit? From the civil court like this, the subordinate co and fast the judgment. This is the judgment, this is the erroneously decided, and whether the application of its judicial mind without having existence of judicial mind of the CPU, and that's why this is not being practiced judicial mind, which caused erroneous decision in the judgment, and just as the same is liable to be set aside. And several times you have processes is liable to be set aside, is liable to be set aside, blah 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 blah. So this is not what tracked as to the language and stylist movement, as we are the person and the people in the world, we are living in darkness, and that's why several aspects will be practiced in the Supreme Court. They have no knowledge at all, and those who are the justices in our country, and those who are the chief justice from earlier to and at present situation, even this is the current situation, they have no knowledge at all, and this is the several writers in our country, they prescribe and they focus in terms of this that is liable to be set aside, and several times this is like this the so this is the system and repetition may be occurred in your systematic while in terms of civil appeal. Oh my God. So this is the repetition. Ladies and gentlemen, if you have no concept at all, just I would like to try at my level best to enlighten the society. But unfortunately, this is the darkness, and we can actually only a single person isn't but exactly the capable or able to enlighten the society, like Mr. Shafiq Nasr. No one can actually grasp or comprehend that the nature of the Lord at all, and that's why we are like behind in our country. Oh my God, we're like behind, and this is the reality. And not only the number 6 grounds to establish this civil appeal before the Court of High Court Division of that should be focused here. Oh my God. So several times before that, the plaintiff did not execute and just sold it, and the defendant in order to cap the suit land. So this is the land, in tracking this the suit land, and there is no properly execution in terms of the sell deed, and that the suit land forced the impunity beyond the knowledge of the flag by practicing fraud and inclusion with the scribe, and just the court has erroneously dismissed the suit. So this is the strong ground. Oh my God, this is the strong ground exactly. That the learned subordinate court erroneously decided not to apply this is the suit land. In tackling the suit land, craft the suit land and the sell deed and the force the impugned deed. That is the impugned deed. So when a question may arise before us, there's the impugned deed beyond the knowledge of the plaintiff, but practicing fraud. Yes, this the keyword is fraud. So to understand this, the fraud like this, the day when the person to whom this is the victim, this is the what exactly the defendant or the respondent or the plaintiff, appellant may be come from the ignorance or the darkness to the lights. That's the cause not to actually practice the. By practicing the fraud, deed was made in that very case, and that's why this is just the court has erroneously dismissed the suit. So how actually that erroneously dismissed the suit, that should be focused here. So this the ground which is very much important, and this is very much this is the strongest ground in the eyes of mine. And not only the 7th ground for the cell deed in question in ex passive void ab initio. Why this the void ab initio? Several times I have focused in this regard that the verb ab initio may be at the Latin term that the contact from the side of minor. That's the verb ab initio, Mohori Bibhan versus Tharmadash 1803. So several times I have focused in this regard that no matter how I say evil, but unfortunately, who actually grasps, who comprehend the words of minds with the language and stylistic movement? No one. No one in our country. So this is the fucking approach. For the subordinate, Seldon is caution in ex passive verb ab initio. And as such, it was not necessary to seek for a cancellation of the said Seldon. There is no question may be asked, and there is no option to arise. Here, the question made as to the cancellation of the said Seldon. And thus the subordinate in the dismissing the suit. The subordinate coach has no knowledge at all. As well as what exactly the little knowledge from the side of the our coach, like the Khalil on that the word which means a little knowledge we have actually. And this is not exception towards the subordinate coach in our country established Dutch. For that the subordinate coach breaks it misread or misconstrued. So this is the erroneous. Misread and misconstitute the saddle principle of law. Which actually, what are the saddle principles in our country to establish the provision of laws? So this that's whether the argument's question is what ab initio, this is the very declaration that the cell did is fraudulent. So there is the option when this is the word ab initio or the word at the time, no question may be asked to cancel this deed. Already we have focused in this is the word. Where the question method the cancellation may be occurred here. There is an option here. So this is the cell that is fraudulent, but not binding upon the plaintiff is well maintainable with asking for the further relief, such as the cancellation of the sweat deed. What is the cancellation of sweat deed? And that can be phrase cut in the word direct to specific relief act. And not only that, society answers the judgment and decree is liable to be set. Oh my God! Again, place is liable to be set aside. How? This is the several times for me. Bikuma to get the one. Oh my God! For that the cell debt being expensive burden as its cancellation is not necessary, the dismissal of the suit for non-payment ad valorem court fee is a miscarriage of justice. It's liable to be said. So here the ad valorem, there is no question maybe as to the ad valorem cut fee cancellation. Yeah, of course, there is a ad valorem is not necessary. The dismissal of the suit for non-payment ad valorem court is miscarriage of justice. There's the payment of this is the miscarriage. Oh my God. So this is very much important, miscarriage of justice, and it's liable to be set aside for that the talker committed an error of resulting. So number 10 may be occurred in this regard if you want to write in this situation number 10. No matter, this is very much easy to understand and to write anyway. For the trial court committed an error of law resulting in error in the decision occasioning failure of justice in dismissing the suit on the ground that the suit was tenable in law for not seeking a decree for cancellation of the above document. So those are the grounds. Now the question may arise at the right side and the distribute to the face banly. We can easily certificate maybe mentioned here in terms of civil appeal, whether yes or not. Oh my God, the sleepy ISIS may be imagined, and this the imagination is more important than knowledge. So the certificate I do hereby certify that I do. So this is the ravishly used I do hereby certify that I have gone through the impugned judgment. Most of the writers in our country and most of the chief justices in our country, they can't actually understand that we can't actually use this as the I do hereby certify that I have gone through the impugned judgment and take it out at 2021 and passed by the learned just first court of the Joint District Judge DHAKA in the trial September 35 of 2029. Whether the 2025, whatever maybe, and in my opinion, the grounds taken in the memorandum of appeal, kept grounds of appeal which I undertake that support the hearing of the appeal before this honorable court. Oh my God. So this is the systematic way. This is what and then you have to rush that you name like Mr. Shafiq Azul, advocate for the plaintiff defend, and that's what is this is the systematic way. Now the last but in closer mentioning in closer, how can actually a student can mention in closer in terms of number one is memorandum of apple one copy and wakalat number in one copy. Just man and decree one copy, second judge's copy, one copy. I want a total 5 or the 6, whatever may be. That should be listed in terms of the enclosure at the left side. Exactly. You have to write that. You have to write on the left side. So, so this is the systematic way. How can actually no one's actually Shoaibur Rahman Midha prescribes that if you want to actually sit in your exam like the Teresa, you can be fast. Of course, I can be fast, and all the justices in our country and all the several chief justices agreed before they can easily grasp that's the reality. And reality means true senses it exists in life. There is no hesitation of the facting approach from you. Exactly, you have focus in this regard. And the Bible board prescribed in such a way you are the genius, and that's why this job is not suitable for you. And several times I have worked against, yes, of course, this is the simple job to the views of mine exactly and true to that knowledge of mine exactly, Mr. Shoaib Rahman Mridha, please. So this is your right in your track that the memorandum of appeal one copy. In such way you have to ending up like this the civil appeal exactly and how to write the civil appeal. But most of the students in our country they can't actually understand that the language or style from the side of law doctor, and that's why this is the unfortunately we have, and this is the very much key for us, and it is a matter of sorrow that media of sorrow that no one actually comprehend that's the strongest movement from the side of law doctor, and that's why several times they can actually defend and they can what exactly they are a failure in our society, and they can cut a good figure in the what exactly realistic life like this the realist theory of the jurisprudence. And today's memo, this is the civil appeal, and next class I will discuss in terms of civil revision, how can actually the provision of laws, and how can you actually study the civil revision and several civil revision. You know, this is the systematic way into DC and PBI and S and GPA. So this is the technical movement. Those who are very much weak in English and those who are the very much weak. Of course, there is no hesitation. They can easily pass in the written exam from the side of High Court Division if you are if you follow the instruction of law doctor. At present situation, as we are the best law academy in the world, not in Bangladesh. This is the totally right in nature. That's the realistic movement from the side of law doctor. And if you have no belief, you have to believe that, believe in you exactly, and just that's the law doctor is the best law academy in the world. And next class I will prefer in terms of civil division and how to draft a civil division, what exactly the district or the court number of application provision of law for is value of suit, and what exactly the value of suit or revision, but even maybe that the impugn jopa, that the judgment or the petition and actions and addressing to the chief justice. But unfortunately the addressing to the chief justice is present here in terms of the civil revision, but no option to insert that is the addressing to the chief justice, honorable chief justice Refat Ahmed, whether this the Hassan Faid Siddiq, whether this is the when maybe coming chief justice in our country, that's addressing media will not be practiced in civil appeal exactly. But on the other hand, in civil revision, you have to write that the addressing to the chief justice, honorable chief justice at present situation, and then the statement of facts, and how can this the case law that the facts occurred before the subordinate codes to the what exactly the appellate court, or the historical movement or the fact count should be mentioned here. So this is treated as the statement of the facts under the heading like the sheet. And not only that, the submissions. Here is the core point here, strongest point to be a genius advocate or the learned advocate in our country, like submission to put here the several case laws that the landmark decision like this in terms of red judicial, for example, that this is Azizara versus Rajuk and others and 2024. This is in terms of the Red City like this in Gulshan. What exactly that Gulshan 1 in Dhaka? This is the what exactly the plot will be watched from the side of Brachuk, and with the practice and movement into attacking this, the processing movement should be fulfillment. But unfortunately, this is the case law should be mentioned here in the submission. But those were the senior advocate, but they have no at all the knowledge movement, and that's why. But practicing lawyer, they can't actually fit here the submission in terms of, in this case, the landmark decision. And several writers in country, they can't actually understand the case laws. Several decision may be inside it here in terms of the submission. And then that's the grounds should be mentioned, and the prayer and affidavit. So those should be the civil division practicing there. But I have focused in this regard the civil division in next class, and then next class civil criminal appeal, and last class second the bail pending appeal, and the quashment proceedings. You know what is under fifth. This is the CRPC movement and the writ petition. What type of writ petition exactly? This is the writ of prohibition, writ of mandamus, writ of what exactly certiorari, writ of quo-warranto, and writ of what exactly this is the habeas corpus 491 from the side of the Code of Criminal Procedure 1898. Okay, today's number, guys. Today's number. You will see next. Bye bye. The next class is on point of civil division. Okay. Bye bye.